Sure. We will get the session started.
Yes, ma'am. One second. Welcome you all for the session on IPR series. Today's topic is IPR for e-commerce. We shall start the session with prayer. Today we have with us two young and eminent speakers, Ms. Harini and Ms. Batma Akila, to discuss on the topic IP for e-commerce. I am glad to introduce both of them for the session participants. Harini is a first-generation lawyer and a senior associate at Ishwar House of Corporate and IPR Laws, with almost 4 years of experience in intellectual property and media law. She was previously associated with Anand and Anand for around 3.5 years. Her core competency lies in prosecution and enforcement of intellectual property rights, which includes appearances before various courts and tribunals, drafting, vetting, and negotiation of all kinds of contracts relating to intellectual property, film and media related contracts. She also been involved in strategizing opinion and providing curated legal advice for companies in the field of agriculture, automobile, electronics, pharmaceuticals, building and constructions, and information technology related sectors. Apart from these, acknowledging the avid mooter she was in law school, Harini has also been invited to judge various moot court competitions conducted by reputed institutions. She is also an active member of International Trademark Association and was a part of winning team of the first INTA Asia Pacific Moot Court Competition 2018. And Akila, Batma Akila is again a first-generation lawyer and an associate at Ishwar House of Corporate and IPR Laws with 2+ years of experience in intellectual property law. She specialized in prosecution and enforcement of intellectual property rights. She has also written many articles and has contributed to the firm newsletter in relations to various aspects of intellectual property and insider trading. Akila has also assisted Mr. S. Ishwaran authoring a book titled Case Digest on Insider Trading. Thank you so much, Harini ma'am and Batma Akila ma'am, for being here. At the outset, I would like to welcome and thank Amrita from CII, who has been meticulously working on finding the resource person for the 15 days IPR series. Amrita ma'am, we welcome you and thank you for all the support you have rendered to Charles and Chain College.
Thank you so much, ma'am, for the introduction. Thank you so much. Yeah. I think we can get the session started now. Akila, can you just share?
Yeah, so I am going to share my screen now.
Yeah. So what we decided for this session was instead of doing it the usual way where it's just going to be a monologue where the speaker speaks and then the participants listen, we thought we will do this as a conversation. It'll be a conversation between me and Akila where we will be addressing questions relating to IPR in e-commerce. And the participants can feel free to interrupt and ask us questions in the middle of the session so that it's more relatable as well when we answer the question and it does not have to be kept towards the end for us to answer the questions. I hope you guys enjoy this session and are able to take some valuable input out of this.
Excuse me, Harini ma'am. Questions will be posted in the chat box, ma'am.
Okay.
They may not be able to unmute themselves and talk. Questions. Chat box.
Okay, fine. So we will just probably look at the questions and answer. Thank you. Yeah. So yeah, let's get started. Yeah. So today we will be discussing about intellectual property rights when it comes to e-commerce. So what? Yeah.
So Harini, tell us what an e-commerce platform is.
Yes. I'll just start with the basics. I'll probably first say what exactly e-commerce is and then move on to what e-commerce platforms are, what are the kinds. So as you all are aware, e-commerce is nothing but trading with or buying and selling of goods and rendering of services through the internet. And it can include anything between just buying and selling of goods or also rendering service such as a payment gateway, which can also fall under the ambit of e-commerce. When it comes to e-commerce platforms, yes, as you're all aware, e-commerce platforms, when we hear the word e-commerce platforms today, the first thing that hits a bell is, Amazon, Flipkart, Snapdeal, and so many platforms like that, which act as a which act as a platform which helps the sellers sell their goods and for buyers to buy the goods from these platforms. They facilitate buying and selling and trading of goods. Now, in the recent past, I would say literally only in the last 2 to 3 years, social media, apart from its role of helping people network, has also entered into this market of e-commerce. As you all know, there are so many people today who sell their products solely only through social media. Like I know so many people who only sell their products. It can vary from anything between selling of t-shirts or selling of books or anything from that to rendering a service like baking of cakes and just selling them through social media platforms and using that as an e-commerce platform to connect to people. Social media has proven to be a very, very effective tool in connecting to people and with interacting to people. Thanks to our technology to have facilitated this in such a seamless manner.
So what do you think is the role of IPR in these e-commerce platforms and social media for that matter?
Okay, I will again go to the basics. What is the role of IP? What exactly is the role of a trademark or a copyright or a patent or a design for that matter? Trademark generally is the source identifier of a particular brand. Today, if I think about a shoe and if the brand Nike or Adidas or Puma strikes my head, then that is the act of a source identification of a product. I think about Nike or Adidas because I know that brand by name, and that brand acts precisely, that trademark acts as a source identifier. So obviously, when we are selling goods, people should be able to remember and relate to what we are doing, right? So when I sell a product on Amazon today, a buyer will go and look for my products by searching for my product along with my brand name. For example, someone will only go and look for Philips hair dryer if they are very particular about buying my brand, obviously. So that again acts as a source identifier and uh, uh, helps in bringing a moment of recall for the public. So that is where I think the role of IPR is so significant. Yeah, that it is important for people, for brand owners to ensure that they protect that IP or that asset that they have in hand. Even
So,
today, yeah, go
yeah,
ahead.
yeah. So, in case I have I own a jewelry shop and I, want to sell my stuff on Instagram. So, do I need to, have an IP protection for that as well? Or for that matter, you spoke about baking cakes and selling them online on social media, right? So, do I need to have an IP? Do I need a trademark protection for that?
For starters, for you to sell a product on a social media platform, it is not a prerequisite that you need to have a trademark, a registered trademark or a trademark application or a copyright application for that matter. But the advantage to that is today, if there is an Instagram by the page by the name XZY, okay, and tomorrow if there is another page which also comes up with the same name XZY and ends up selling a very similar set of goods that you are also rendering, what happens in that case? How can you stop someone? You know that someone's copying from you, right? You know it right in front of your face that someone's copying from you. How do I stop that person in such instances? This is where the role of a trademark comes into play. If I have a trademark registration for XYZ, uh, it is just easier for me to waive out that certificate and say, hey, I am a registered trademark owner, so don't use my trademark. Because when they do so, they're automatically violating you of your right to that brand of which you own it. So, like you asked, if someone does that on social media, it is not mandatory for you to have a trademark registration, but it helps in ways wherein if you come across a page like that, you will be able to report that page on Instagram and take it down. But for that, for you to do so, you might need a trademark registration for Instagram to authenticate that you are the original owner.
Right. So you mean to say that a statutory protection is always stronger than one with no protection, right?
Correct.
Yeah.
If you know, to all the participants as well, in India, it is not a mandatory requirement to have a trademark register. A trademark right or a protection is given even without a statutory protection. That is to say, you can enforce your right against someone if they copy your trademark. But the process is pretty long and it's cumbersome because it starts from the stage wherein first you will have to prove that you are the trademark owner, and then it goes on to the remedy that you will actually get. When it comes to a registered trademark, since it's a statutory right in itself, you have a statutory remedy that arises out of it. So like we all have birth certificates, right? Where it clearly indicates where we are born, who our parents are, and everything. So a trademark certificate, registration certificate is similar to that. It just clearly indicates the source of origin and who the owner is, which is just easier to prove when it comes to a court of action.
Right. Thank you, Harini. So coming back to our sellers. So how do you think these sellers, and they protect themselves, their brands, and their so many products that they sell under their brands from all these counterfeit and duplicate product sellers, fake ones?
Okay, so e-commerce platforms today, after we must say that after a lot of trial and run, and after being involved in a lot of suits, they have taken the effort to ensure that the seller's intellectual property rights are not violated. In the past, before e-commerce platforms started having separate procedures for enforcement of IP rights, what used to happen was these e-commerce platforms like Amazon, Flipkart were all made party to the suit when a counterfeit product was found available on their website. So the seller, that is whoever the seller is, they had put it across to the court that these platforms should also take the due care and should take due diligence to ensure that these counterfeit products are not sold. But let's be practical. It's not possible for Amazon or Flipkart to go through every product that's there on their listing to check whether it's counterfeit or whether it's coming from the actual owner. It's typically impossible. And time and again, these websites tried ensuring, they tried putting across this notion that it's not possible for them and all that. So eventually what they started doing is, they started bringing about methods. Like, for example, Amazon has Amazon brand registry, and Flipkart has Flipkart brand registry. So what happens in these cases is, the seller, when he is selling his product on Amazon, he also has the option of going and registering his brand with Amazon brand registry. So what should one person do to register their brand in the Amazon brand registry? It is mandatory for someone to have a registration. So this is where the role of a trademark comes into play.
Sorry, Harini, by registration, you mean a trademark registration. Am I right?
Correct. Yeah. So
or can it even be an application, or should the trademark be registered itself?
It can be both an application and a registration, but it's just most of the times it's just considered if it's just a registration. It's just easier for the application to process through, the brand registry application to process through.
Right.
And yeah, but like I said, there have also been instances where Amazon has also accepted application. It's merely for Amazon to understand that you are the original owner, the source identifier. So yeah, I'm sorry. Yeah. So going on from there, we look at it. This is where the role of a trademark comes into play. It is important to protect your brand by seeking a statutory protection. So when that happens, when you are a seller in these e-commerce platforms, you will be able to register yourself. And when that happens, if there is a counterfeit product that's found on the website or on the platform, because you are a registered owner in the Amazon brand registry, the takedown process for you to take down the counterfeit good that's there on the listing is easier. All you have to do is, you'll have to just notify Amazon saying, hey, I found a counterfeit product here. There'll be a form that needs to be filled out, and Amazon will cross verify and check whether you're a part of Amazon brand registry's registered trademark owner. And once they verify that, then they will take down the listing. Apart from this, like I have mentioned in my first point, it is very, very important that as a brand owner, you are very vigilant about your rights. The law, the law does not favor the one who sleeps over his rights. It's a standard statement that in most of the cases, courts say, if you were so vigilant, why did you sleep over your right? So that's, yeah, the first step to curtailing all of these counterfeit products is to be vigilant about your rights. And then the third point comes to take down notices. So when I say take down,
I'm sorry, I would like to interrupt you here.
yeah,
So I am a brand owner, say I own the brand TVS. Now I want to sell my products on Amazon or Flipkart. So I do not form part of this brand registry, but I do have trademark registration. Now I find a counterfeit product being sold on Amazon. Now what remedies do I have? What will Amazon do, or what can I do to enforce my rights, my proprietary rights over my product? How do I take down the fake products, the counterfeit products? How do I chase them?
Even if you are not a part of Amazon brand registry, you will still be able to submit your registration certificate to Amazon and say, hey, I am the registered owner, please take it down. And even in those cases, so that is why there are takedown notices which you can fill it, takedown notices forms which you can fill it up and send it to Amazon and intimate them about a counterfeit product that's there available on their platform. However, despite doing so, if Amazon still does not take the listing down, then the next course of action will be to reach out to the seller who's selling the counterfeit products. You can probably send him a legal notice, tell him that you are the original owner. You might as well just take it down and yeah, you demand that they take it down. Despite that, if they don't do it, then your next process or your next method or approach should be to approach a court of law and seek for infringement of your trademark rights and passing off of your trademark rights. So when you approach a court of law for such a thing, it is better if you make Amazon as a party to the suit, because the direction will be subsequently given after it is identified that you are the original owner. Thereafter, when the court gives an order, within 72 hours of receiving the order, Amazon is bound to take down that listing.
Right. So Amazon can be held liable for such, for letting these counterfeit products get sold or, offer for sale online. Am I right?
Amazon technically cannot be held liable because Amazon, Flipkart, all of these social media platforms, they all fall under the category of intermediaries. So when you say intermediaries, they are typically only facilitating a sale and the payment and everything that is related to the sale or the service that is being rendered on the platform. They have no involvement in changing or adding anything to the context of what is being listed. They don't have they don't modify what is being listed or what is being sold, or they don't review or anything of that sort. So they fall under the ambit of an intermediary, and these intermediaries are being governed by the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. After quite a number of cases that's happened in the that's happened in the past, the Information Technology Act rules has been amended to bring this as a part of it. And here the intermediaries have been given certain have been given certain mandate to do things a certain way, which involves this takedown policy of wherein if they are notified if they are notified by a competent court, then by after receiving the order, they are supposed to take down that listing in 72 hours. However, they cannot be held liable for a counterfeit product that's been sold online.
Right. So in case of counterfeit products, you mean to say that these social media platforms will get sued left and right.
Yes.
So then what kind of measures do they even take? Like they have opened a wide platform for, they've offered variety of modes in which sellers can sell their products. So what kind of measures or protection do they even offer these e-commerce platforms?
As a precursor, what they do is this is also covered under the intermediary guidelines, where the websites are mandated to put it across to the users of the platform that the sellers or whoever is posting any content on such platforms should not violate anybody's intellectual property rights. So when I say violate the intellectual property rights, they cannot violate anybody's trademark rights, patents, designs, copyright, anything for that matter. So this is a precursor, and this most of the times these websites and these platforms also get away with that. They also say, hey, I've put it across in my platform. It's only up to the seller to look at it and ensure that he is not selling it. I cannot go and review every single product. So subsequently, what they did, in order to show that they are also taking measures to curb these counterfeit products, they decided to start programs. For example, if you look at Amazon, I'm sorry, I'm taking Amazon as an example for most of the things, but yeah. So Amazon has these programs such as Amazon Brand Registry, then IP Accelerator program. What typically happens in IP Accelerator program is, I am a seller. So if I am going to sell on Amazon, and if I want to register myself with Amazon Brand Registry, but like you said, I don't have a trademark. So what do I do in that sense? I might be a very, very small guy. I might not know people. I might not know IP or lawyers. So what happens is, Amazon has tied up with several law firms in the respective jurisdictions wherever it offers services. And these law firms, so when Amazon helps these sellers by connecting them with these particular law firms, which will help them in obtaining a trademark registration. The next one is, there is another initiative called transparency. What typically happens in this is, transparency is an item level tracing service where brands actually serialize each unit of their product, which they manufacture, with a unique code. So what happens is, Amazon scans these codes and verifies the authenticity of the product before it actually reaches the consumer. The best part about this is, consumers also have consumers can also scan the code with their mobile app, Google Lens or something, to confirm the authenticity of the product. The next one is on Project Zero. So with respect to Project Zero, what Amazon has done is, it's intended to drive these counterfeit products down to zero, as it literally says, by combining brand knowledge and with machine learning. They use the help of machine learning to feed information into the Amazon's automated software, which will allow efficient and effective prevention of counterfeit listings in the website.
So you are talking about artificial intelligence here, right?
Correct. Yeah. So what is the Amazon has done, has taken one step ahead amongst all other platforms, and what it has done is, after identifying a counterfeit, Amazon has also been a part of a party to the suit. Like, they have sued along with the original seller. Amazon and the original seller has sued the manufacturer of the counterfeit product together. So in order to ensure that the merits of the case is strong enough, and yeah, so that social media and the e-commerce platforms these days take so much of initiative to ensure that such counterfeiting and such misrepresentation and all that, those don't happen.
Right. Okay. So this is with respect to a brand name. So now I don't copy, there is a counterfeit product that exists. Say a handbag. It resembles that of what I sell, but the name of the handbag is different. The brand name is totally different. So there is no existence of confusion in the brand name, but the product looks exactly like my handbag. What do I do in this kind of situation?
Well, in these situations, like Amazon is doing for, with the help of this transparency and with the help of Project Zero, apart from all those services that are being rendered by these e-commerce platforms, alternative measures that can be taken by a seller would be to ideally purchase a product, see if that product is actually infringing their design in nature, and if so, and if it is found to be a counterfeit or a replica of what is being sold, then he can take, like I said, he can take the recourse of either addressing that counterfeit seller by addressing a legal notice to him and asking him to stop using it or asking him to stop manufacturing it, or he might approach a court of law and obtain an injunction against him to stop using it. So this is where it becomes important for a manufacturer or a seller to have protection for his products as well. That is either as a patent, if it is a patentable product, or have for the design feature, aesthetic part of the product, which is covered under industrial designs.
So you mean to say that I can file for a design registration for my handbag in question?
Yes, you can. But yeah, as it is in other IPs as well, it is important to conduct a search. It's called a prior art search. A prior art search, and ensure that there is no design that is similar to that in the market today, and then protect it. But the most important thing in patent and design protection in India is it is important to ensure that you do not publicly display your product or your patent before you actually seek a registration. Most of the times, people are not able to enforce their rights because they are not aware of this fact that it has to be, previously applied for or registered before they actually launch the product. It does not have to be registered before they launch the product. It has to be applied for before they launch the product.
Right. Thanks, Harini. So now, these days, no, before even approaching your e-commerce like Amazon or Flipkart, what a person directly does is they Google their product, Google what they want. So I want to know what are these Google keywords and AdWords that appear at the top of the page of every Google search. So can you tell me more about that?
Yeah, it's I would say it's pretty interesting as to how infringement of a IP can happen in the most remotest ways possible. It's just very it's shocking and surprising. Those are the kind of words that you can use these days. What happens is Google keywords, I mean, they have a tool called the keyword suggestion tool. So what happens is Google will automatically pull out those terms or trademarks which are the most searched ones in their search engine by the internet users in relation to the business or services of the advertiser. Say, for example, if I'm advertising shoes, footwear. So Google will automatically suggest terms according to that. The obvious term could be footwear, or sandals, or heels, or things, stilettos, stuff like that. So what happens is, once it gives you a suggestion, the advertiser, whoever is the advertiser, he will have the option to bid on the particular term. The best part about this is, there can be multiple people, even your competitors can be bidding on the same term.
Well, they might not even be the owners of that trademark, right?
Correct.
They're just
Exactly.
competitors.
Exactly. So what happens today, I know that a certain a certain mark, say for example, since I'm talking about footwear, let me just say Bata. Bata is a very well-known footwear brand, right? So today, if I am the actual owner of Bata, but there might be someone who is my competitor, but he wants to get his website listed as the first one, or in the first three of the results. What he will do is, he will go and start bidding on the word Bata. Assuming that he wants to get listed in the first three results, he will ensure that he takes his bid to the highest level, and also obtains the keyword as his own. So when that happens, he will have the ability to list his website as a first one, because he has actually bid for the keyword. So that is why there are, I'm sure all of you might have come across in several scenarios where if someone is actually looking for something or searching for a keyword on Google, sometimes we end up receiving some unrelated results. We'll actually be wondering, why is this even here? And that this ad keyword, or this keyword Google keyword, is the answer to that question, because anybody can bid on your term or your trademark, which is of your interest, only to unjustly gain and from your reputation and goodwill, and to just get his or her website listed in the top 2 or top 3.
Total anti-competitive practice.
Exactly. It's a completely anti-competitive practice.
So now, how does these meta tags, the meta tags, how are they different from these keywords then?
Your Google keyword will be a keyword which will generate, which will be the keyword to generate results for what you're looking for. Right? It's more or less like I said, it will be the word for you to find what you want. When it comes to meta tags in itself will be a part of a website's source code. So you might not really know, as a owner of a particular brand, you might actually not know, why is this even getting listed here? And he is my competitor. Why is his website also getting listed in the same time mine is? I had the opportunity to deal with a case where the case was completely on meta tag infringement, wherein the defendant, he had very, very cleverly, I'm not going to be able to say the brand, so I will just say it in XYZ. So my brand was XYZ, and his brand was completely unrelated, say ABC. And what he had done was, he had, as a part of his source code, he had involved, or he had put in the keyword XYZ in his source code as a meta tag. So what happened then is, when people were searching for my brand XYZ, even though his brand was completely unrelated, it also popped up on the list. So that is when we realized that this guy is actually infringing on our trademark by using it without our authorization as a part of his source code. So then we approached the court. We sued him for infringement of trademark, but through meta tags. And the court was kind enough to actually grant injunction and say even meta tag infringement happens these days. And it is important for brand owners to vigilantly look into source codes as well to ensure that nobody is unjustly claiming on your reputation or Google.
So coming back to our very serious problem, Google AdWords, what is the remedy that's available for me if the bidder gets to be in the first place in a Google search page, while I am the actual owner, I don't even appear. So what do I do now?
So, okay, Google has, Google also, like other websites, it has Google Adword policies where it gives you the option of complaining to Google through a complaint form where you can enter in details regarding your trademark, and then you can use that complaint form to seek Google to take down or rather freeze the advert and ensure that it does not get misused by anyone else. But in this, there are certain prerequisites that Google requires as an owner for you while filling in the complaint form. But I don't think it's necessary to get into those technicalities because it's a pretty cumbersome process in itself, and it won't make sense to explain it here. But the thing is, as a part of its policy, Google surely also does expressly say that when they give out these AdWords or keywords for bidding, they actually do not investigate or restrict trademarks as keywords, because, like I said, it's impossible for a search engine like Google to check whether this is a registered trademark or not. So it's more or less on a complaint basis that they remove such, or they restrict such use of AdWords.
All these are mainly because these e-commerce platforms, or Google for that matter, cannot become the judge of similarity of brand names, or am I right? They cannot decide that. Is that what you're trying to
say? Yes, absolutely. Because they will not have the they will not have the appropriate knowledge to decide on which is infringing in nature. So it's like saying, nobody can, for example, if you're traveling in a train, you can only ensure that you are trying to safeguard your property, but you can't ensure that there is no thief that's there on the train. And if something else happens, you obviously just complain, right? So it's more or less like it does not work on a prevention basis.
Also, they cannot really do the job of a trademark registry or an IP office or the court for that matter, right?
Correct. You're absolutely right. Yes.
So this is for Google keywords, but in case of meta tag, meta has become a famous word thanks to Facebook. So what do we actually do there? Like, for that, we directly approach the court after sending a legal notice. Am I right?
Yes, that's your best approach towards this, because like I said, it will not be possible to because your website is something that you create, right? There is no a particular place where you go to create it for you to be complaining about it. So that's why it's the best course of action will be for you to take an action of infringement on that party outside, in a court, in a competent court.
Correct. Thanks, Harini.
Yes.
So,
just a second, and I guess
1 second.
Yeah, I think I'm going to share my screen now. Yeah. So I guess we are going to take turns now because I have answered your question or questions all these while, and now it's time for you to answer my questions. Yeah. So, we spoke about Google AdWords, we spoke about the meta tags and all that. We typically see all of these things emerge or start from having a platform or having a website in itself, right? So I'm sure most of us here would have come across fake websites, like fake websites, which instead of Amazon, it will be Amazon. Just replace the N with M. And we will be receiving subscription emails and all that from such domains. So what happens in such circumstances? How, as Amazon in itself, I myself have a brand that I have to protect. What should I do if someone infringes upon my right or violates my right by starting a website like Amazon.com, something like that? What do I do? What is my recourse? You're on mute. Um, I think Akila did not enjoy me questioning her. I think she's gotten dropped off. Just give us a moment, please. Yes, she's just sent me a message that she's reconnecting. I'm so sorry. Until now, do any of the participants have any questions?
No questions in the chat box, ma'am.
Sorry, just give me one more minute. If Akila, yeah.
Yeah, I'm here. Sorry, guys. Yeah, so Hani, can you repeat your question? I'm so sorry I got dropped off.
Yeah, so I was asking, so we dealt with AdWords, meta tags, and all that. So, in case of a website like Amazon, if Amazon's domain name, like if someone comes up with www.amazon.com with just replace N with M, and that's just very similar to what Amazon sounds. It's obvious that that person wanted to copy it. What happens in that case? I mean, I know it's infringement, but it's a domain name infringement in itself. But what happens in that case? What is the recourse that someone has?
So here, talking about domain names, the infringement part here involves not just the domain name, but also the trademark. Agreed? Because these days, any trademark owner, trade name owner, or brand owner, the first marketing tool that they ever create is to create a website. So this is such a powerful tool because when somebody wants to buy a product or invest in some service, they open the website to see how good of a service they're offering, or what kind of policy they even have, right? So when such a powerful tool exists, there's the automatic infringement. So these kind of domain name infringement, like that is trademark infringement, forming part of domain names, have become a really serious issue. So these can be tackled by going for domain name dispute resolution policies, like it's just an arbitration that they do. Before even going into domain name dispute, should we talk about the formalities, or how a domain name should
Yes.
get even
I was-
registered, Harini?
Yeah, I
Yeah.
thought I would stop you there and ask you,
Yeah.
first, how do I even register my domain name?
Yeah, so now it's a very simple process. Like in this process, one doesn't even need to show the ownership or proof of ownership of a particular trademark, after which they are going to name their website. Say my brand TVS, tvs.com or tvs.org. The major part of this domain name is TVS. That is a trademark in itself. So now to register this domain name, you don't really need to show the proof of ownership. You just have to find a third party service provider, like say the register. People must have heard about GoDaddy, Two Cows, and Google domains and all that. So these people are third party service providers who register your domain name. So when you talk about registration of a domain name, you will have certain choices. Now you also need to know about the kinds of domain names. Like there are two kinds of domain names. The top level, generic top level domain names called as GTLDs. They are all those .coms, .info, .net. They operate on a global level. And then you have our CCTLDs, which is just your country code level domain names, like .co.in, or if it is a UK based website, .uk, if it is India.in, or if it is Singapore.sg, anything for that matter. So there are two kinds of domain names. One is the global level ones with the .com, and then the country level ones with these things. Right. So here, before registering a domain name, you go to this registrar and you registrar, that is the GoDaddy or Two Cows or whoever. They enter into an agreement with you, for the domain name registration, which forms the basic legal ownership of that particular domain name. That agreement gives you the legal ownership for your domain name. So this is a very simple process. You don't need to show any proof for this. Yeah.
Okay. So, say for example, I have a brand and it's pretty famous, but I don't have a website. I'm an old school person. I don't have a website and all that, but people know that I exist. So what happens tomorrow? I want to start a website or render my goods through this platform, and I want to start a website. So I go for a domain registration. But I see that that domain is not available. That I come across that website as unavailable, or that domain as unavailable. What happens in that case? What can I do?
There is always an alternative domain name, like alternative extensions. Like you can always go for .org or .co.in or .net or anything for that matter. But if you find somebody existing with that .com that you desire, say your choice is to go for XYZ is your brand name, XYZ.com. There's already somebody who exists in that name, who already have that domain name registration, like it's already owned. Now you need to understand if it is a genuine ownership, like for that XYZ, do they have a registration, like trademark registration, and are they using that website in relation to the products and services that they have applied their trademarks for, or is it just a blank website that is not in use? So that is where cyber squatting comes in. So these days,
You're
these
using very technical terms. What is cyber squatting?
so cyber squatting is when a person, a third party, buys, a domain name, like our example of xyz.com. Okay, he might not actually have ownership trademark registration for XYZ, but he just bought the xyz.com from a registrar and he's parked it, like he's just blocked it, because he knows when the actual owner, the owner of XYZ is going to come and ask him for that website, because the actual owner is actually using the products, the brand, and he's actually promoting it, right? So he will want a website. This guy knows that that famous person exists, that the brand owner exists. Now, taking the advantage of registering a domain name prior, like he just parks and blocks that website. He knows that he can exploit and use that website to commercially extort from the actual brand owner, because he is going to come back and ask, I want xyz.com. What are you doing with that? When you see these kind of cyber squatting can easily be identified when the website is not in use. Like there is just a website, it's either blank, or it will be like, the website is not in operation, or there will be an error that shows. These kind of websites, from these things, you can actually find out that, it's just parked, like they're not actually using it. An actual website will have actual use, like they'll sell products for delivery or any, even for an article for that matter. But usually these cyber squatters, their websites are blank. They don't have active use. Yeah. It's totally, done with the malified intention to extort money from the actual famous brand owners.
Okay. What can I do for that? I mean, what is my recourse when something like that happens?
So you are asking me what remedies as a brand owner you have against these cyber squatters, right?
Correct. Yes.
Right. So the best way to address the case of cyber squatting would be to initiate a domain name dispute resolution process. It is basically an arbitration process, binding arbitration process against the cyber squatter. Okay, so you also have different kind of domain name dispute resolution processes, like for the global level GTLDs, right? The global level domain names, the .com, the .org. So they can approach the they can take hold of this uniform domain name dispute resolution policy, and they can file for remedy. So the local level here in India is the IDRP.
India. Correct.
Yeah, correct. INDRP. So this is being administered by the National Internet Exchange of India. So the UDRP, that is the Uniform Domain Name Dispute Resolution Policy, is being administered by the Internet Corporation for assigned names and numbers.
Okay.
It is important that you choose your domain name dispute resolution policy wisely. So if it is a global domain name, then you go for UDRP. If it is a local one with .in or .uk, whatever it is, you go for the local domain name resolution policies.
Okay. Well, I guess that that sums up most of the issues we generally deal with when it comes to e-commerce platforms in itself. I think we've pretty much covered everything here. I mean, yeah, including a domain name dispute as well. Like I said in the beginning of the session, I think it's very important for a brand owner to have or to ensure that his trademark is protected by seeking appropriate registrations for it. So when that happens, the process of enforcing your right against someone who is violating it is just easier. And yeah, I think that's the crux of our presentation today. So
looks like you need protection, legal protection for everything, for a design or for a word or for a brand name or for a logo, considering so much of malafites like your Google ads and your meta tags and your counterfeit products.
yeah, obviously, because it's a piece of your intellect, right? I mean, it's an intellectual property that has been created by an individual. It's everything. I mean, art is everything. It's the toughest thing to do these days, and I think it's worth protecting it as well, because it easily gets copied as well.
Because and you've also thought about it, like it's an idea and you need to protect your idea.
Exactly. And yeah, as you know, you can't obviously protect your idea in itself. You can only protect an expression of an idea. Today, I can't go and protect a script. So yeah, so in that case, I think we can't actually just protect an idea in itself. You need an expression or a medium where this idea is expressed, and only that can be protected.
Rise to yeah, social media culture and all your social media e-commerce also have, like, you know, your brand needs to be protected. Like it should be your utmost, you should give it utmost care as a brand owner, for that matter. Yeah.
The floor is open for questions. Like I said in the beginning itself, you can ask questions while we were doing the session. But now that we have come to the end of our session, we are still open to questions if you have any.
I think the questions will be put up on the chat box, right?
Correct.
Yeah.
Thank you, Mr. Romkar, for saying that we have resolved almost most of our queries by answering it during our session itself.
Thank you, Harini ma'am and Akila ma'am. It was actually an interesting session.
I hope the session was a bit different from others where we could do it like a conversation.
More than a presentation, it is just a kind of conversation which we can involve ourselves, and we just we feel live doing the session. Thank you so much. And I don't see any questions, queries so far from the participants. I think you are too clear on. So, shall we go for the formal vote of thanks, or you want me to wait some time?
Should we wait for some more time?
Yeah, I think we could wait for five more minutes.
Sure,
And,
sure.
Yeah.
I have a query. Like we are talking about, kind of registering our trademarks and how it is active in e-commerce and all those stuff. As an academician, we always get trapped in clone journals, which is like, again, through, a kind of website, they try to get our publications, and which is this name of that journal is very much similar to the Scopus journal or a Web of Science journal. So is there any way where you can really look into, as a customer point of view, or as a publishing presenter point of view, is there any way whether to identify that it is a clone journal or an original journal?
The best means to actually check whether it's the original one or a replica of Scopus is to probably check with Scopus directly if they have anything of this sort, because like you're saying, there are instances where these journals actually take money and then publish, if I'm not wrong. So one thing that should be done is Scopus should be taking a what do you call it? It should be taking an action against these journals, so that for the welfare, or probably for the betterment of these people who publish and present, for academicians and everyone. So ideally, it's Scopus that should, for example, Scopus that should take the action. But otherwise, from a presenter's point of view, it will be best if you do your homework to see if they are actually, if the Scopus or a well-reputed publisher is actually doing this publication, so that you can cross-verify and see.
Harini, can I interrupt and add to what you've mentioned
Yes.
here? Hello, everyone. I'm Harini and Akila's colleague here. And just to add to what Harini has just mentioned, regarding the journals, I'm sure you're all aware of the concept of registrar of newspapers and the registration of any magazine and journals with a central registration authority under the Ministry of Information and Broadcast.
You talk about RNI numbers.
RNI, that's right. So that is also one of the means there is a RNI registration number that's generally given for any approved journals that are published and circulated to the public. So that is also one of the means to ensure and verify the authenticity.
So regarding this RNI, is there an RNI for e-journals also?
Which journal? Sorry, I didn't.
E-journals, electronic journals.
They
have only PDF content.
At present, RNI's scope is limited only to physical journals and periodicals and magazines. It doesn't extend to e-journals, but under the Information Technology Act, you have the intermediary guidelines that has come into place in 2021. And the set guidelines and the rules have extended and put in place certain norms that place certain obligations and liabilities on print and e-publication related intermediaries. So that will start applying to such. Of course, there is a litigation that is ongoing in terms of those guidelines. There have been certain stays, injunctions that have been granted, where the operation of such rules have been stayed by both Madras High Court and the Bombay High Court in parts. So it'll be interesting to see how that pans out.
Yeah.
Thank you so much, Sai sir, for pitching in. Thank you so much.
Thank you.
No, the participants say that they're very clear. Few of them say that they are very clear about the topic, and for few it is very new.
I'm so glad we could do something like that, ma'am. Thank you.
Thank you so much. I request Priya to formally propose the vote of thanks.
Yes, ma'am. Good evening, everyone. It's an honor to propose the vote of thanks for today's session. I would like to thank the Almighty for making today's session a success. I extend my gratitude to our speaker, Ms. Arini and Ms. Batma Akila, for taking time to be a part of the FDP on research and IPR, for sharing her knowledge and insights. I thank all the participants who have taken time out to attend today's session. A big thank you to our secretary and associate secretary for the constant guidance and support. My special thanks to our principal, Dr. S. Batnavadi, and vice principal, Dr. S. Rukmani, for giving us the encouragement we always need. Last but not least, I would like to thank Dr. S.T. Deepa, our internal training team and technical team, for all the efforts and coordination for this session. Once again, I thank you all. Thank you, ma'am.
Thank you. Thank you so much.
Thank you, Harini ma'am and Batma Akila ma'am. Thank you so much. Looking forward for more such interactions for our students also, because the next generation should know how to, they are actually very creative in creating minds and all those. They are putting their ideas creatively. So they should be given awareness for this kind of IPR. Thank you so much. Thank you. Thank you, Sai sir. Your input was really informative to us. Thank you so much.
Thank you. My pleasure. Thank you.
Thank you.